judge says global de-indexing order against Google threatens free speech. Canadian courts can't rule the internet, at least not outside Canada. A U.S. federal judge has stopped a ruling from the Canadian Supreme Court from going into effect in the U.S. The Canadian order would have ordered Google to de-index all pages belonging to a company called Datalink, which was allegedly selling products that violated the IP of Vancouver-based Equustek. Further, ReadingGoogle must alter worldwide search results, per orders from Canada's top court. When the order came down earlier this year, Google filed a lawsuit in U.S. federal court seeking to render the Canadian order unenforceable stateside. Google called the Canadian order repugnant to the First Amendment, and it pointed out that the Canadian plaintiffs never established any violation of their rights under U.S. law. Equustek never showed up to defend itself in the U.S. court case, making a Google victory all but assured. On Thursday, U.S. District Judge Edward Davila made it official, granting a preliminary injunction that will stop Equustek's hard-won Canadian ruling from being enforced in the U.S. Davila held, PDF, that the order violated Section 230 of the Communications Decency Act, which prevents online platforms from being held responsible for content posted by others. Further, reading company that sought to control Google search results is a no-show in U.S. court. Davila found that Google satisfied all the elements needed for Section 230 protection. Datalink, not Google, provides the information at issue, Davila wrote. Google's search engine helps users discover and access content on third-party websites, but it does not provide that content within the meaning of Section 230. An injunction against the Canadian order would not only protect Google, but serve the public interest, Davila held. The Canadian order would hold Google liable as the publisher or speaker of the information on Datalink's websites by forcing intermediaries to remove links to third-party material. The Canadian order undermines the policy goals of Section 230 and threatens free speech on the global internet. Further, ReadingGoogle tells judge, "Don't let Canada force us to alter U.S. search results." Google also raised First Amendment arguments against the Canadian order. Davila didn't consider those arguments, finding that Google had flat-out won the case on Section 230 grounds. The spat began when Equustek, a Vancouver-based maker of networking devices, sued a former distributor called Datalink Technologies. Equustek accused Datalink of illegally relabeling products and stealing Equustek intellectual property to make its own products. Datalink left the province, but continued to do business online, selling its products worldwide from an unknown location, according to Canadian courts. Equustek sought and ultimately got court orders forcing Google to de-index Datalink web pages. When the Canadian Supreme Court ruled on the case earlier this year, some called the ruling the first global de-indexing order.